All right, here's a public-facing version written from your POV that explains what you're actually suing. No, I'm not appealing anything. I'm suing over what they already did. Let's clear something up, because a lot of very serious people in robes seem confused. I'm not asking a federal court to redo my state case. I'm not asking anyone to overturn a conviction. I'm not asking for a magical super appeal. I'm suing because state actors already violated my constitutional rights in real time in ways that caused real harm, and those harms don't magically become legal just because a state court later wrote them down. Think of it like this. If a cop punches you in the face, you don't have to wait for a jury verdict to sue over the punch. You sue because you got punched. Same idea, just with more paperwork and worse attitudes. What this case is actually about in human language. 1. I was punished for speaking. I filed motions, I objected, I asked questions, I asserted rights. The response wasn't, we disagree. It was, stop talking or we'll hold you in contempt. That's not court management, that's First Amendment retaliation. And retaliation is illegal the moment it happens, not after a final judgment. 2. My lawyer stopped being my lawyer. I told my court appointed attorney what I wanted to do. He did the opposite. Then he told the court it was basically for my own good. That's not strategy. That's loss of defense autonomy and ineffective assistance. You don't need a conviction for that to be unconstitutional. The harm is losing control of your own defense. Full stop. 3. They slow walked the case until the process itself became punishment. Delays, suspensions, detours, evaluations, all while the clock kept ticking. The Constitution doesn't say, you get a speedy trial unless the court is annoyed with you. A speedy trial violation is the delay itself. You don't wait until the building collapses to notice the foundation is cracked. 4. They ran proceedings off the record, witnesses excluded, conversations not transcribed, decisions made where accountability couldn't reach. That's not a bad ruling. That's procedural due process failure. If the process is corrupted, it's unconstitutional, even if no verdict ever comes out the other end. 5. They escalated punishment because I pushed back. No bail hold, bench warrant, extradition threats. Not because I was dangerous, because I was inconvenient. Punishment used as leverage is still punishment, and excessive punishment is illegal when it's imposed, not later. 6. The judge stopped acting like a neutral referee. When the person running the game starts punishing one player for speaking up, excluding evidence, and retroactively fixing the record, you don't have a bad call. You have judicial bias and fraud on the court. That injury is losing a neutral tribunal. You don't need a verdict for that either. 7. They obstructed my access to the courts. Motions struck, threats issued, records withheld. That's not case management. That's obstruction of justice. Interfering with someone's ability to raise constitutional issues is illegal, even if the court later pretends it was tidy. 8. Evidence disappeared or was never produced. Off-the-record hearings don't leave transcripts. Ignored records requests don't leave paper trails. Destroying or hiding evidence is its own violation. It doesn't turn legal just because the underlying case is still pending. 9. They refuse to give me public records. FOIA and state public records laws aren't optional. They don't say, unless the requester is annoying. Withholding records is a completed statutory violation. No appeal required. 10. This wasn't random. It was coordinated. Prosecutor, defense counsel, court, same direction, same outcomes, same retaliation. That's why RICO exists. Because sometimes the problem isn't one bad actor, it's the system closing ranks. Why this is not an appeal, and never was. An appeal says, the court made the wrong decision, please fix it. My case says, you already violated my rights. I was injured. I'm entitled to damages and declarations. Those are different universes. I'm not asking a federal court to reverse a state order. I'm asking it to recognize that constitutional violations already happened, and that writing them into an order afterward doesn't make them legal. There is no final judgment requirement for retaliation, denial of counsel, due process violations, excessive punishment, obstruction, spoliation, public records violations. If there were, the Constitution would just be a suggestion until the end of trial. The quiet part they don't want to say out loud. If courts can dismiss cases like this by saying, this looks like an appeal, then judges can retaliate in real time, prosecutors can escalate punishment, defense counsel can sabotage autonomy, and the Constitution only becomes enforceable after the damage is done. That's not federalism. That's immunity by exhaustion. And no, that's not how the law works. The TLDR. I'm not appealing a case. I'm documenting what they already did. And if that makes people uncomfortable, it's probably because the Constitution is supposed to. If you want, next I can tighten this into a Substack TikTok script, turn it into a one-page explainer graphic, or write the polite version courts pretend not to understand. But this is the truth, plain and sharp.